Let's resume the meeting. Get everyone a chance to sit down. Okay, thank you. So, just before we, I'm proposing we adjourn this item and come back to it later. But before we do, there was a couple of questions that were put to Mr. Wares that were he didn't have the hadn't done the research to answer. And the Chief Executive is going to help me with those questions. Are you? Councillor Dick.
Around the AMO.
Councillor Dick.
Yes, well, two. One issue that's been raised is the question of security for payment of water. And of course, the first recourse is to cut off supply if you have to, but after that there's a 2-year bank guarantee. Now, it was implied that 2-year bank guarantee only existed for the first 2 years. My understanding is that it's a rolling 2-year. Tell me what it is.
It's in the so there's nothing in the water use agreement that says that letter of credit facility doesn't roll on. In the course of time, it will ultimately become a Ruataniwha limited partnership decision as to whether they believe that letter of credit's needed or not needed, and that's a commercial decision which will be made 5, 6, 10 years hence, really. But so there's nothing that says that it won't be there. It'll be a sensible risk-based commercial decision on the basis of some reality, and maybe I can deal with a more fundamental point here than simply a letter of credit. So we have advice. I'm not going to tell you which bank it is, but in terms of what's the risk of a water user defaulting and or the bank not picking up, in the case of default, the bank not picking up the both the farming operation on selling it and retaining the water. Round about zero. There are no defaults currently, haven't been for a number of years, either of water users paying their water charges or paying, in the case of co-ops, share costs, etc., and the debt arising in terms on their balance sheet in terms of owning those shares. There's been none for this particular trading bank's enterprises, and they have a very, very large agricultural book. So the point being is that there's a clear and underlying commercial reality that farming properties that have access to reliable water, that have built up their infrastructure and productivity on that assumption, on that basis, are one, of very good customers of trading banks, and secondly, the bank, it's a loss-making scenario if either part of those parties chooses not to pay the water fees. So the risk is very, 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 very low.
Mr. Chairman, second question was, in the very rare event, and you might like to comment on the statistical likelihood that the dam does not fall completely, and that the obligations to supply, assuming high take-up, which will happen, is in that event, is the water shared out pro rata, and do they pay for the water that they receive, or do they pay for what they've contracted for?
Well, I'll answer your last question first. The contracts, the water user contracts, are take-or-pay contracts. So, in a what we would call a curtailment scenario, the reality is it's a take-or-pay contract, and so therefore those charges are locked and loaded, right? The second point, though, going back to a management practice in the case where there's, and there will be dry years, I mean in the 42 to 44 year record, we work on a basis of around about, and I'll just keep it really quite simple, about 95% reliability. There's no guarantee there's going to be absolute 100% reliability in the scheme, never was, never will be. But it will have very high reliability, but in curtailment years, in the water use agreement, there's a process that the scheme will need to go through once, and it'll be post-financial close with the water users, which will be development of a set of water supply protocols, which will in effect deal with the curtailment regime that will operate in some extreme years, and that's pretty standard practice.
There was one other question around insurances, which volume. Yeah, for sorry, both or partnering a dam break with consequences downstream. Project issues, but like a catastrophic event. So with the dam itself and downstream consequences.
So I can only answer, to be fair, I can only answer generically on that point because I haven't been spending a lot of time in the insurance part of the deal. But the Ruataniwha Water Limited Partnership will there is insurance for those instances, and you'd expect that it would be prudent that the limited partnership will insure for both for catastrophic failure, for failure and also any other public liability risk. And that process, the insurance process, is subject to a detailed due diligence process as part of the whole due diligence exercise underway with our co-investors.
Councillor Barker.
With respect, that's what causes me to be nervous. See, the insurance cost of this will be quite high, so it will be in the interest of the investors to minimise their costs. And in the event of a catastrophic failure, because it's a limited partnership, their only assets which will be exposed will be the asset that they own in the dam. Now, if a catastrophic failure occurs, their asset is zero. So, that's the end of their liability. So in actual fact, it's in their financial interests to minimise their insurance costs in the case of a catastrophic failure, because if it is, they're out of here. It's a little bit like a mining company does not got particular interest in what happens in the long term, just wants to take the mine, the gold or the coal and go. Long-term costs are not its interest.
I think that's overstated. Sorry, Councillor Barker, I'll be a wee bit direct there. I think you're vastly overstating the point. One is dam insurance for the sort of issues that you're concerned about is common, and it's very common. The asset class, dam asset class, is actually very low risk and insured accordingly, actually, because if you actually, that's a well-developed international insurance practice. And the third point is that these investors are sitting there in a 70-year concession. They've got a very, very significant financial interest in seeing the scheme operate, the dam performing to its standards, and having appropriate insurance so that those sorts of issues can be managed appropriately, because they've got a 70-year financial exposure. So I think you're overstating it. Sorry.
Can I add also that I believe that the banks will impose an insurance obligation in addition to that. So in fact the LP won't have a choice about insurance.
Yeah, that's correct.
Okay, Councillor Balfour, you
So we're discussing the water user agreement now? Is that?
No. I think that was the answer we had from Mr. Wares anyway. There was nothing further to add.
Well, I guess then I do have a process question. This is a substantial agreement. When will councillors have the opportunity to understand this agreement? I could see that you noted the appearance yet to be made by the certificate business, and so it would seem to me, okay, that's fine. Maybe Mr. Ware should come in after he's had a chance to actually see what that document says. But the workings of these water user agreements, I think, are very material to what confidence we should have in all of this, and particularly confidence with respect to how effectively the environmental mitigation requirements of the Board of Inquiry will actually be met. So will we or will we not have an opportunity, if not today, at some point, to hear these kind of questions addressed, or would you be happy to authorize 2 billable hours to Mr. Wares to answer my questions in his office? I don't care.
Would 2 get you there, Councillor?
Through you, Mr. Chairman, the questions I think need to be asked and answered today, whether or not that's in public excluded or well, okay, so then it can be answered in open, and we'll have to be guided by the chair as to when this conversation actually then resumes.
It's a couple of very simple things. My understanding is you've already had a review of the water use agreement. You've had your legal advice, yes you have, and I'm sure the Chief Executive there can clarify that for you. To the extent that there are individual water use agreements, there's a certificate from Bell Gully identifying those agreements and are they enforceable, which is the fundamental question. So that advice will be part of the HBRC directors' process and their own due diligence and their own recommendation to you as council, so that's coming. And the parties, because it's private information, the parties will be, the parties who have signed water use agreements will be available on a confidential basis to councillors. But I'm also going to make another point, which you raised, Councillor Burford, which is around are the farm environmental management plans enforceable? Well, actually, you should probably be asking your regulator that question because they have a obligation to have those FEMPs audited, all of them audited annually for the first 3 years and then on a rolling 3-year basis thereafter. So your regulator will actually have a deep insight into the compliance, performance and the standards of the FEMPs.
The regulator, our staff may have views on all this, but there are some legal aspects to this, as of, for instance, and some of this is just either confirming or not confirming, not terribly difficult, but is it correct that until a water user has an approved farm environmental management plan approved by HBRC, that the water user agreement has no standing? It is a condition that must be met, and if I understand all the convoluted definitions in this water user agreement, it appears that folks who have signed up have 12 months or so to apply for these. It looks like there's a certain date at which before you can supply them water, it has to be approved, so there's some window here, it would appear. But until they are approved, what's their legal status? Because we're building a financial structure on the assumption that all 100 and whatever they are, 96 whatever, are ironclad, but they're not until that point.
Happy to answer that.
Councillor, the way the agreement works is that the clause you refer to, the 12-month window to get the FEMP up and running, is a condition subsequent. The way it works is that the parties actually have to get that FEMP across the line, and if for any reason it hasn't been approved by the scheme when water first flows, then the water user will be on the hook for the water charges. There is an exception, there is an out, and that is if the consents or the farming activity that's proposed is such that there is a regulatory reason why that farm environmental management plan can't be approved. And so the assessments that have been undertaken, as I understand it, that those risks are extremely low. So that if someone has not got their farm environmental management plan up and running or has decided they want to use that mechanism as an out, there is a very objective test that sits as to whether they can get it.
Would you not agree that HBRC has a overriding incentive to approve farm management plans once it gets 3 years out here and is starting to need to count the dollars from these would-be irrigators?
The HBRC can't be in breach of its consent, so it can only approve a FEMP if it's remaining within its consents.
Sorry, I need to make a point of clarification here too. It'll be the Ruataniwha Limited Partnership, not HBRC. Well, it'll have a number of reputable investors there with a high public profile that will clearly want to perform in a transparent, accountable manner in relation to their consents.
Councillor Bevan.
Thank you, Chair. I think you're right, Andrew. We have received advice on the water user agreement, but it's since been significantly rewritten, and there's a couple of sections here, sections 10 and 11, that deal with this approved maximum output. Now, I've read, it's really complicated, and I've read it 3 times, and admittedly at 10 o'clock at night.
That's right.
I have no idea what the requirements are, and somebody needs to explain it because it's quite important.
Okay, so Tom, you might get landed with this one. So firstly, I agree. The AMO clauses are really quite complex to understand. But the fundamental, all the scheme is really doing, and Tom, you just correct me if I'm wrong, but essentially what the scheme is doing there is that across the across the consented footprint, it has an allocation of a nutrient allocation, and the scheme is incentivizing, in effect, or leaving room at a future point for water users who don't necessarily, say, you might have a arable farmer that might be, say, leaching at 7 or 8 kgs of N per hectare per year, but have a theoretical allocation under an LUC of something in the order of 30, say 35 kgs. What we're trying to do is make sure that they're incentivised to operate effectively, and so it's creating a potential nutrient transfer platform, which I don't actually think is going to be needed, but it just means that in the foundation stones of the framework that's there if it is, as an efficiency thing. That's broadly the philosophy behind it, but when you try and write that in legalese, it's really difficult.
It took 3 pages to say that.
Yeah, no, I know that, Councillor Bevan, and that's the issue of getting a bunch of lawyers to try and write something on that. But it's not I think, Tom, in terms of materiality, it's
I think
it's not a biggie, really.
No, and I mean, I think the
Yeah.
the key constraint in there in terms of this whole transfer regime is the clause that says that nothing in this transfer regime, can put the LP in a position where it's in breach of its consents. And so, one of the, I suppose as my understanding is, with the discussions with water users, there was a concern that they could come in with a farm environmental management plan, and then the scheme could be, looking to, sell more water in a specific zone or something like that. And so this was designed to stop the scheme acting arbitrarily in terms of existing farm environmental management plans, and just giving some assurance around how that process would be managed.
Okay, I think we've chased this enough in this round. Have you got a final question?
Other final questions to you?
To me? Shoot.
Chair, just to finish the questions, my final questions to you, and looking at the recommendations we're about to go to, just on the conversation we had around the table here today, there seems to me to be still a number of outstanding legal questions that councillors have. Some are going to be raised and solved with Deloitte's and so on. There's still some other things to come. And with that in mind, I'm just wondering how we can then, in 3, say, resolve satisfied with the legal advice. It seems to be if we say that, we're saying that the matter's therefore closed, and I just don't think we can do that, given that there are other matters to come. I think this. So I wonder how you're going to resolve that, and on the basis that it seems we haven't quite got the end of the road yet, how we can then also say to, in 4, delegates the chair to consign it with minor matters outstanding, because I don't think there are. I think there's more than minor matters.
So can I offer an assurance that I'm going to propose that we adjourn this item now,
Okay.
and come back to it after the public excluded session. Okay.
And you'll answer my question then.
And then we'll deal with it in public. So.
Okay.
Okay.
Thank you.
So let's adjourn this item, move on to the next item. Thank you, gentlemen, and Mr. Wares, we'll see you later on today at some stage.